I thought I would talk to you today about mortgages because even though it's a large and expansive topic, it is relatively self-contained within land law, and this makes it a good area to choose for exam questions or coursework questions. I think that the key thing you're going to have to remember as we go through this lecture is that ultimately mortgages is about striking a balance. On the one hand, we have people like you and me who want to take out a mortgage in order to buy a house. And on the other hand, we have the banks who have a commercial interest in making money and getting a good return on their investment. With that in mind, let's get started with mortgages. So the first thing that we're going to want to do in this area is to actually define our terms. And in this very simple diagram, I've tried to set this out. So on the one hand, we have the mortgagee, who is the lender and most commonly a bank. And on the other hand, we have the mortgagor, who is often the homeowner. Now, it's really important that you remember these two terms and don't get them mixed up. To be honest, there's no real easy way of remembering which way round it is. The way that I used to do it is that the mortgagee is the evil banker, but any way that you find to remember it is going to be good. Now, in the introduction, we talked about the idea about how this is a contrast between the mortgagee, the bank, and the homeowner, the mortgagor. But to put it in more specific legal terms, this is really a contradiction or a balance between, on the one hand, the law of contract and the law of equity. Now, the law of contract would state that if a person signs up to a mortgage agreement, it doesn't matter what terms are in there, they've put pen to paper, they've signed it, and therefore they should be bound by it. On the other hand, we have equity that seeks to establish fairness in law, and it says that if a person signs a contract that has really unfair terms, in other words, they're unconscionable, then that contract should not stand and could be amended by the courts. So that's the balance that we really have here. Obviously, the mortgagee, the bank, will be trying to enforce the law of contract, and most commonly the mortgagor will be focusing on equity. And so with that in mind, the first thing that we're going to look at from the mortgagor's perspective is the equity of redemption. And essentially, this is just the right of the homeowner to pay back the mortgage in full, including interest and costs. Obviously, if you take out a mortgage, you eventually one day want to pay it off, remove that mortgage charge from your home, and basically just go on leading your life without the bank involved. Nowadays is quite different. This is sort of post 1925, so the mortgagor, or the homeowner, retains full legal title to the land, subject obviously to the mortgage charge. Before that, it was the mortgagee who held the legal title, so that was quite different. Also, the contractual date for redemption now, i.e. the day when the mortgage has to be paid back, has very little meaning. In the past, this was really important because all of the money had to be paid back on one specific day, and if it wasn't paid back on that specific day, then the mortgagee would simply just take the property. So it was a really strict focus on contract law in the past, whereas nowadays equity plays a greater role. The first clog or fetter on the equity of redemption that we're going to talk about is the exclusion or postponement of the right. And the idea behind this is that the mortgagor, or the homeowner, can redeem the mortgage at any time between the redemption date, i.e. the date set out in the mortgage agreement for redemption, and the eventual sale or foreclosure. In other words, until the mortgage is actually paid off or the bank has to foreclose and take over the house. Key case in this area was Samuel and Jarrah Timber that we'll spend just a minute on just to sort of get an idea for it. In this mortgage agreement, there was an option for the mortgagee to buy the property within the first 12 months. And this created the potential for a situation where the mortgagor could pay back the loan in full, but the mortgagee would still be able to take over the property. And obviously this interfered with the idea of an equity of redemption, even though it was clearly established within the contract. And so the courts reluctantly did step in and say that that term was illegal. However, an interesting case to contrast this with is Lewis and Frank Love Limited in 1961. In this particular case, there was a similar situation, but there were two separate agreements. On the one hand, there was the mortgage agreement that was pretty standard and normal, And then separately, there was another agreement between the mortgagee and the mortgagor, which essentially gave the right to buy the property at any time within a certain period. And because there were two separate agreements, the court said that this wasn't really a clog or a fetter, it was a separate agreement which was distinct from the mortgage. Now, it's important to point out that this doesn't always mean that if there is a separate agreement, that will guarantee that the option will stick. In the Kreglinger case that we'll also come back to in a bit, it stated that it's important to look at the reality of the situation. In other words, are these really two separate and distinct agreements, or is the reality of the situation that we're really just dealing with one agreement between the mortgagor and the mortgagee, and that this option is acting as a clog or a fetter on the right of redemption? The other point that we can make in this area is on the mortgagee's side, and they are allowed to postpone the earliest date of redemption. This is really important from a commercial sense because obviously the mortgagee wants to make a good investment and has to be able to make some money in order for there to be some incentive for them. However, while they can postpone this date of redemption, this postponement itself cannot be unconscionable. And to explore this in more detail, we can go back to the Knightsbridge Estates Trust that we mentioned earlier. In this particular example, the date of redemption was postponed for 40 years and was at an interest rate of 6.5%. Unfortunately, after the agreement was signed, the interest rates fell dramatically and the person was stuck at this 6.5% interest rate. This might seem unfair, and that was the complaint in the courts, but if you remember the principle from the Knightsbridge Estates case, it was this idea of unfairness or unreasonableness itself wasn't enough to justify the intervention by the courts. Instead, there has to be unconscionability. And in this particular example, even though it was perhaps unfair or unreasonable terms in the mortgage, they certainly weren't unconscionable, and so the mortgage was allowed to stand. Moving on then to another clog or a fetter, we have unfair collateral advantages. And this is where the mortgagee, aside from making money from the mortgage, also perhaps seeks to get some other collateral advantage. And equity is always going to view with suspicion any attempt by the mortgagee to gain some sort of collateral advantage. The basic mortgage agreement itself should be enough, and anything apart from that is going to be viewed with suspicion. So with this in mind, Lord Parker in the Kreglinger case that we mentioned earlier spoke about collateral advantages and said that they would be struck down in three particular situations. Firstly, in line with equity, if they are unfair or unconscionable, then they will be struck down. Secondly, if they're a penalty that clogs the equity of redemption, then obviously this links in with the first point that we made in terms of equity of redemption, and so that will be struck down as well. And anything generally that is inconsistent with this right to redeem will be struck down if it is seen as a collateral advantage to the mortgagee, i.e. something outside of the normal mortgage agreement. The most common type of unfair collateral advantage that you will probably come across is called a Solace Agreement, and this is where the mortgagee requires certain products to be sold at a commercial property. So a good example of this would be, say you wanted to run a pub and you didn't have enough money to do it, and a brewing company came up to you and said, well, we'll lend you the money as part of a mortgage, but also as a collateral advantage to that, we want you at this pub to only sell our type of beer. Other similar examples that often come up in the case law are petrol stations. So BP or someone like that might say to you, okay, we'll give you the mortgage to buy a petrol station, but as part of that you can only sell BP petrol. So that's the idea behind a Solace Agreement, and the courts obviously view these with a bit of suspicion, as they do with any collateral advantage. They obviously should be limited in their duration. In other words, they can't just last forever and ever. And in terms of putting some type of figure on it, Esso Petroleum and Harper's Garage looked at two examples of Solace Agreements in the context of petrol.
On the one hand, there was one Solace Agreement that lasted 5 years and another one that lasted 21 years. And the courts allowed the one that was lasting for 5 years to stand, but they dismissed the one that was for 21 years, saying that that was too long and therefore it was unfair. So that gives you some idea that probably around 21 years is probably a bit too long. Something that lasts, say, the lifetime of the mortgage is more likely to be fair and less likely to be struck down by the courts. When we're thinking about Solace Agreements, there are also other areas of law that can come into play. In particular, if we go back to contract law, we can think about the restraint of trade issues, and also within the context of EU law, if some of you have already studied that, you might want to think about competition law, and in particular Article 101. So beyond collateral advantages, the final category of a clog or a fetter was oppressive interest rates and charges. And the UK is somewhat unusual in that the mortgagee or the bank often has discretion with interest rates, but this does not mean that they can be oppressive. So a good example of this is Paragon Finance and Nash, where the interest rate was variable and could be set by the mortgagee. Now, the mortgagee during the lifetime of this particular mortgage was relatively reasonable with how they adjusted the interest rates. And so the court said, well, okay, you might consider it unfair, but you've signed up to this and it's not unconscionable, so we're going to allow it to stand. The other interesting fact about Paragon Finance is, for those of you who've also studied public law, this considered the idea of Wednesbury reasonableness in the context of interest rates and charges, so that was quite interesting. A good example of one where it has been reduced, the interest rate, is the City Land and Property Holdings Limited and Dabra case. In this case, an interest rate of 57% was held to just be completely oppressive, and so the courts decided to reduce it from 57% all the way down to 7%. Now, when it comes down to penalty rates, the idea behind this is that it should not be deliberately harsh, but it should reflect the cost that's been endured by the mortgagee, say in administration costs for going through all the processes, but they should not be penalising in the sense of just sort of deliberately high for the sake of penalising the mortgagor. And this goes way back to the case of Hollis and Wise in 1693. So there's a really long line of authority for this idea. But we can also look to the Financial Conduct Authority Handbook, which is certainly a lot more recent. The Financial Conduct Authority came about as a result of the Financial Services Act 2012. They came into being in about April 2013, and they produce a handbook on how you should conduct your business when giving out mortgages. It's basically guidance and rules for mortgagees to follow. And so it's quite a useful reference point, and you might see a few references to it in your textbooks and also online if you're looking at articles. And so MCOB just simply stands for Mortgages Conduct of Business, and 12.4.1 reiterates this principle in Hollis and Wise, that the penalty rate should be reflective of how much cost has been endured by the mortgagee, rather than being deliberately penalising. So those are the three areas of clogs and fetters. Before we do move on to the final topic, it's worth saying that although we've talked a little bit about contract law and equity and striking the balance between those two, one of the other key areas is also consumer protection. And the UK is somewhat unusual in the sense that not really much focus is put on mortgages within the context of consumer protection law. And this seems a bit strange because obviously a lot of people take out mortgages each year from banks and building societies, but the consumer protection law has not necessarily caught up with that, and so we're left with relatively generic provisions that are seeking to help people out. Nevertheless, Section 140A1 of the Consumer Credit Act 1974 is quite broad and can help people out within the context of mortgages. Basically, it allows the court to intervene where the relationship between the creditor and the debtor, i.e. the bank and the homeowner, is unfair to the debtor because of either the terms of the agreement, the way that the creditor has exercised or enforced their rights, or anything else that's done by the creditor. And so it gives the courts a wide degree of margin to alter agreements and to intervene in that relationship. And that could easily apply to mortgages. In more recent times, we have Section 62 of the Consumer Rights Act 2015, and this basically sets out the requirement for contract terms to be fair. In particular, you might want to have a look at Section 62.3, which takes the definition from a set of 1999 consumer protection regulations and brings that into the modern statutory law. So the final topic that we're going to have a look at is undue influence and misrepresentation. And this might often occur within the context of mortgages. Say if a husband and wife are buying a house together, the husband might want to sort of take out the mortgage and might pressure his wife into doing so. And so we're going to try and look at that relationship and what sort of pressure would count as misrepresentation or undue influence. And the basic definition we have there from RBS and Ettridge number 2, one of two key cases in this area, is basically it's misrepresentation where the complainant has been misled as to the facts of the transaction, or undue influence is basically where that person has had their will overborne or coerced. So worth keeping that in mind. And firstly, financial transactions are voidable on the grounds of misrepresentation. And this comes from our second key case in this area, Barclays Bank and O'Brien. Moving on to undue influence though, and this founds an equity in the complainant to void a transaction. So it's a little bit more complicated than misrepresentation, which just allows for a straight voiding. There's this founding of an equity. And so we need to look at this in a little bit more detail. And the first thing to do is to look at the type of undue influence that's actually involved. On the one hand, this can be actual, as in threats and violence, or it can be class 2, which is presumed, i.e. it arises out of a relationship. So once we have that class 2 idea, and this is probably the most common one because it's more subtle, we can look at the different types of relationships. So we have class 2A relationship, which are set out in certain categories. Generally, these don't really apply to the mortgage situation. The only one that might be relevant would be a solicitor or a client, but worth looking at those classes that are set out in Barclays Bank and O'Brien. Class 2B is probably the most common one, and this is where the complainant places trust and confidence in the other person. So you can see it's a much more broad test, and it's that proof of trust and confidence that we're seeking to establish. I should point out those classes, class 1, class 2A, class 2B, all come from a speech by Lord Brown Wilkinson in the Barclays Bank and O'Brien case. So make sure that you refer to that when you're answering a question in this area. So in terms of looking at this relationship and in particular the transaction has to be not readily explicable by the relationship between the parties, and also cannot be accounted for by the ordinary motives of ordinary persons in that type of relationship. So basically what we're talking about here is there's almost a subjective test and an objective test when looking at the relationship and also the transaction. So it's going to be up to you in a problem questions type scenario to examine the situation from not only the perspective of the person who is claiming undue influence, but also to try and look at the relationship and the transaction objectively and come to some sort of decision. Now, the first point when you're going through a question is to mention that the initial burden is on the complainant to actually show that this relationship exists. In other words, to show that there is trust and confidence. But once that is actually established and once it's accepted that there is a relationship, particularly within class 2B, then the burden passes on to the other person to essentially disprove the undue influence. And the most common way of doing this is to show that the person got independent and professional advice. A good example of this is in Papui and Gibson West in 2004. So what about what the role of the lender, i.e. the mortgagee in this type of scenario? Because the undue influence may occur between a husband and wife, and so the question is, what position does this put the mortgagee in? Well, if the lender has actual or constructive notice of misrepresentation or undue influence, then they themselves are actually put on inquiry, and they should be looking into this further. In the Ettridge case, Lord Nichols held that lenders are put on inquiry when a person offers to stand surety, i.e. stand for the money for his or her spouse, anyone else in a non-commercial relationship of which the lender is aware, or a company where the person holds shares. So it's a relatively low bar for a person or a lender to be put on inquiry. However, say the money itself comes from both the husband and the wife, in that type of situation the lender is not put on inquiry. However, if we're going back to a situation where the lender is put on inquiry, then the burden then falls to going to an independent solicitor, and this comes back to the idea of in Papui and Gibson West of independent professional advice. The independent solicitor has to explain the nature of the transaction, and in particular the practical consequences and seriousness, i.e. that the person could lose their home or lose the property, emphasize that this is an optional decision and that they shouldn't be pressured into it, that they should be making it from their own free choice. The solicitor should also explain it in non-technical language, and then finally confirm that the surety, the person who is putting up the money, does actually wish to proceed. So that's quite a lot of pressure that's put on an independent and professional solicitor, and you'll often see cases of negligence where the case is actually brought against a solicitor. If you're thinking about this as part of an essay question, one of the things to think about is whether this puts too much pressure on the solicitor or whether the bank themselves should actually do more within this particular context.
And there we have my first lecture on mortgages, which is particularly focusing on the rights of mortgagors or homeowners. If this does come up as a problem question, then you're going to be wanting to think about that contrast I spoke about right at the start between mortgagors and mortgagees, in particular focusing on the difference between the contract that was signed and therefore should be enforced, and on the other side thinking about whether that contract itself is unconscionable and therefore equity should get involved to try and help out the homeowner somewhat. The courts do have a variety of powers in this area and can alter the mortgage agreement, as we've seen in some of the cases. Think about the different types of situations that might arise in the problem question, in particular the equity of redemption and the different clogs and fetters, and also think about the idea of misrepresentation and undue influence, focusing on those cases of Ettridge and Barclays Bank and O'Brien. I hope that you've enjoyed this lecture. If you did, make sure to leave it a like and subscribe for more lectures in the future. Hopefully I'll do the second part, which is going to focus on the rights of the mortgagee next week and perhaps also remedies as well. And also, if you've got any comments or any questions, then leave those in the box below and I'll try and get back to you as soon as I can. Thanks very much for watching. Bye!